Good evening and welcome to your Week 3 lecture, Chapter 2 in Understanding Human Resource Management. This week we will focus on operating within the legal framework. Your learning outcomes have been posted to your Blackboard shell and are also listed in the next two slides. It will be important for testing purposes that you are able to identify, define, and explain the following learning outcomes while answering some of the questions that are identified not only within this presentation, but also in Chapter 2 of your textbook. As the HRM close-up shows, operating in a highly regulated environment creates another level of legal scrutiny and compliance. Laws have been written to protect the employer and the employees. These laws reflect the values of society, and in some situations, laws have been enacted because of poor management practices in the past. Therefore, it is important for managers to understand the legal context in which they have to operate. Managers and employees can no longer behave and act in certain ways without severe consequences. When managers ignore the legal aspects of human resource management, they risk incurring costly and time-consuming litigation, negative public attitudes, and damage to organization morale overall. Some laws address not just legal issues, but also emotional ones. For example, human rights legislation is paramount over other laws and concerns all individuals regardless of their gender, race, religion, age, marital status, disability, family status, sexual orientation, national origin, color, or position within an organization. All employees, including managers, need to be aware of their own personal biases and how these attitudes can influence their dealings with one another. It must be emphasized that whether managers act a certain way unintentionally or intentionally, they are responsible for any legal actions they take. Beyond legislation, there is also an expectation in today's society that treating employees in certain ways is just good business. Therefore, the concept of diversity management and inclusion in a multicultural society has become part of business simply because it makes good business sense. It is important to remember that we have gone beyond what is required by law in our human resource management practices. Canada has two distinct sets of laws that govern: federal and provincial. Federal laws apply to everyone who resides in Canada. For example, everyone who earns an income must pay taxes. Other laws are handled at the provincial level. For example, the provinces are responsible for determining who can get a driver's license. Although Chapter 2 in your textbook discusses specific employment laws, other kinds of laws, such as common law, contract law, and government regulations, can also have an impact on HR. For companies that are federally regulated, there are two basic employment laws: the Canada Labour Code and the Canadian Human Rights Act. The Canada Labour Code covers basic employment conditions, labor relations, and health and safety in the federal sector. The Canada Industrial Relations Board administers this law. The Canadian Human Rights Act, like the Canada Labour Code, applies to all federal government departments and agencies, crown corporations, and businesses and industries under federal jurisdiction, such as banks, airlines, railway companies, insurance and communications companies. It is administered by the Canadian Human Rights Commission, which makes decisions on complaints that involve discrimination and harassment. The concept of a certain level of basic human rights is a part of the very fabric of Canadian society. Of increasing concern for managers and HR professionals is privacy legislation. There are two primary laws. One that applies to only federally regulated companies, like banks and airlines, and then the other one that extends to federal legislation to provinces and businesses within the provinces. These laws are the Personal Information Protection and Electronic Documents Act and provincial legislation commonly called the Personal Information Privacy Act. These acts have a direct influence on how companies and managers handle employee information and the rights of employees regarding this information. Both acts enhance the protection granted to employees on their personal information that a company retains. Organizations can use the information only for its intended purpose. Organizations can no longer collect personal information without disclosing the full use to their employees. Furthermore, organizations must seek written permission from employees to disclose personal information. For example, if you want to get a car loan, your employer is obligated to seek your written authorization to disclose your pay to the lending agency. These acts have been mostly noted in the monitoring of emails, use of social media, and website visits of employees while at the workplace. More information in regards to this topic will be covered in Chapter 9. Human rights legislation. The legislation that has had the most far-reaching impact on employment conditions has been the Canadian Charter of Rights and Freedoms, particularly the area of human rights. The Charter passed in 1982. It guarantees certain rights and freedoms within our society. What it has done for employment legislation is ensure that such legislation is consistent with its principles. Rights under the Charter were reinforced when the first human rights legislation was passed. Although the original human rights legislation was at the federal level, all provinces have enacted similar laws. The basic foundation of human rights legislation is that all individuals should have an opportunity equal with other individuals to make for themselves the lives that they are able and wish to have, and to have their needs accommodated consistent with their duties and obligations as members of society, without being hindered in or prevented from doing so by discriminatory practices based on race, national or ethnic origin, color, religion, age, sex, sexual orientation, gender identity or expression, marital status, and so on. Although the legislation is designed to protect individuals, it doesn't cover every situation. For example, age had been defined to be between the ages of 19 and 65 in most jurisdictions. However, most jurisdictions have now eliminated the 65, which means that in most cases the notion of mandatory retirement would now be illegal. Employers now need to be vigilant regarding how older workers are treated so that organizations do not have complaints based on age discrimination and forced retirement. In regards to discrimination, the essence of human rights legislation, both federally and provincially, is to prohibit discrimination on a number of grounds. Many employment barriers are hidden unintentionally in the rules and procedures that organizations use in their various human resource management practice. These barriers are referred to as systemic discrimination. Systemic discrimination is the exclusion of members of certain groups through the application of employment policies or practices based on criteria that are not really job-related at all. In regards to bona fide occupational requirements, although it is necessary to ensure that discrimination does not occur, there is a provision in all human rights codes for employers to have a certain employment qualifications list that is somewhat discriminatory. This is called a bona fide occupational qualification. For example, Alberta requires that liquor store employees must be at least age 18 years of age to sell alcohol. This is justified if the employer can establish its necessity for business operations. This can apply to any and all prohibited grounds under human rights legislation. For example, a recent complaint before the BC Human Rights Tribunal alleged that the employer was being discriminatory under the provisions of disability by not allowing an employee to use medical marijuana. The employee insisted that they needed to regularly smoke marijuana at work. Employers are required to protect employees' rights when medication is required. However, employers also have a responsibility to protect employees at work and ensure a safe work environment. The tribunal, although sympathetic to the employee's illness, determined that the employer did not need to take the accommodations to the point that others at work might be at a safety risk. Therefore, an employer not only needs to examine job requirements and demonstrate that a certain characteristic is absolutely essential, but also needs to consider the work environment. In regards to duty to accommodate, this is another concept that has arisen from human rights decisions. The duty to accommodate is a requirement that employers adjust employment practices so that no employee is discriminated against on the prohibited grounds. This is a legal obligation. So as new prohibited grounds are added to any human rights legislation, they too become eligible for accommodation. When an accommodation request is made to the employer needs to very thoroughly investigate and consider methods by which the employee's particular needs, like family status, gender expression, or disability, can be accommodated in the workplace, including whether the specific tasks can be organized in a way to deal with that need. It's important to remember that accommodation works both ways. Both the employee and the employer must live up to the agreement. It is an interesting case dealing with accommodations due to disability and a request to return to work. The Human Rights Tribunal of Ontario determined that the employer had a duty to accommodate and could require the employee to attend a medical examination by a physician of the employer's choosing. The employee alleged that to do so was discriminatory by not allowing a return to work based on an accommodation from the employee's doctor. A tribunal decision was recently upheld by the Court of Appeal in Ontario. The court reaffirmed the tribunal's decision that it was reasonable to seek alternative medical assessment. Besides prohibiting discrimination, human rights legislation prohibits harassment, as harassment is a form of discrimination. However, some provinces have enacted legislation that broadens harassment beyond prohibited grounds. For example, bullying is considered a type of harassment and is also specifically identified in occupational health and safety legislation. Harassment is usually considered to be any conduct or comment that a reasonable person would consider objectionable or unwelcome, including any unnecessary physical contact. It can take many forms and can be one incident or several incidents. It is not acceptable, for instance, for one coworker to strike another. It is also not acceptable to make personal comments that are offensive to another person. When dealing with harassment in the workplace, a manager needs to ask whether a reasonable person would consider that behavior or action as harassment. If the answer is yes, then the manager is expected to act accordingly. It is interesting to note that what is considered harassment in today's workplace was sometimes considered acceptable behavior not too long ago. For example, it used to be acceptable to call someone a name that reflected their ethnic background. Although for some time discussions of harassment have focused on general harassment and bullying, the concern that sexual harassment is still very prevalent is becoming news in headlines recently. The Canadian Human Rights Commission defines harassment as follows. Harassment is any unwanted physical or verbal behavior that offends or humiliates you. Generally, harassment is a behavior that persists over a period of time. Serious one-time incidents can also sometimes be considered harassment. Harassment occurs when someone makes unwelcome remarks or jokes about your race, religion, sex, age, disability, or other of the grounds of discrimination. If they threaten or intimidate you because of your race, religion, sex, age, disability, or any other grounds of discrimination, or if they make unwelcome physical contact with you, such as touching, patting, or pinching. Many employment barriers are hidden unintentionally in the rules and procedures that organizations use in their various human resource management practices. I had discussed this a few slides back in regards to discrimination. I had touched on the definition of systemic discrimination. This would be an important concept to remember. As you can see, I'm somewhat skipping through these definitions because we have already talked about these components in this lecture. In regards to enforcement of human rights legislation, the federal government and each province and territory have a commission or similar agency to deal with complaints concerning discriminatory practices covered by the legislation. For example, the Canadian Human Rights Commission deals with complaints from those employees and businesses covered by the Canadian Human Rights Act. These commissions can act on their own, or if they feel there is sufficient grounds for finding discrimination. The agencies also have the ability to interpret the Act. Figure 2.3 in your textbook presents a flow chart of the process used to resolve complaints. I've also included the flow chart at the very end of this PowerPoint presentation. Generally, when a complaint is received, an individual contacts the Human Rights Commission or tribunal to file the complaint. In regards to screening and investigation, a commission or tribunal representative will work with the complainant to determine what occurred. The employer will be notified to determine its perspective. Specialists are assigned by the commission and tribunal to assist the parties in finding a mediated solution. This is a voluntary and confidential step. Next comes the tribunal hearing. When a case is referred to a tribunal, there is no guarantee that the complaint will be upheld. Furthermore, if the tribunal decides the complaint is valid, it can order corrective measures such as a human rights training, a change in the employer's human rights policy, or payment for lost wages, pain, and suffering. Human rights laws are enforced in both federal and provincial jurisdictions in a manner similar to that described. The majority of cases are resolved at the investigation stage. If no agreement can be reached, the case is presented to the Human Rights Tribunal. The tribunal studies the evidence and then makes a decision. Failure to comply with the remedies prescribed by the tribunal are enforceable through the judicial system and may result in prosecution in provincial court. Individuals can be fined between $500 and $1,000, and organizations or groups between $1,000 and $10,000. These can vary across the province. This is Figure 2.3, Human Rights Commission Dispute Resolution Process. All federal, provincial, and territorial jurisdictions have passed employment standard laws specifying the minimum obligations of employers. The names of the laws usually include the term employment standards or something similar. However, the minimum obligations for federal companies are covered under the Canada Labour Code. Usually included in this type of legislation are items such as hours of work, minimum wages, overtime pay, vacation pay, public holidays, and who is covered by the legislation. Standards will vary between provinces. In Alberta, for example, certain provisions, such as keeping overtime records, do not apply to architects or engineers. The legislation also typically reflects the views of the specific government with regards to its social policy. This legislation is important as it applies to all employees, unionized or not, and because it specifies minimum obligations of employers. Every employer, large or small, needs to be aware of this legislation. This is particularly true if the organization also uses contract workers. There may be circumstances in which the contractor is considered an employee. Even though the use of contractors has been popular within organization, Ontario recently passed legislations that will have more protection for these contract workers. An agency or commission that both interprets and enforces the law administers the legislation. For example, if employees feel that they are not receiving the right amount of vacation pay, they can contact the agency and find out what the right amount should be. If they are getting the wrong amount, the agency will then contact their employer and start an investigation. Furthermore, other legislation may influence what standards must be met. A case involving a collective agreement that allowed the employer to adjust automatic wage adjustments during parental leave was deemed to be violating human rights legislation, and also was ruled that it was against the Employment Standards Act. Sometimes organizations think a certain provision in these standards does not apply. This needs to be considered carefully. In regards to labor relations legislation governs both the process by which a trade union acquires bargaining rights and the procedures by which trade unions and employers engage in collective bargaining. In some jurisdictions like Ontario, the legislation applies primarily to workplaces in the private sector, but also covers certain parts of the public sector, like hospital employees. Ontario has separate legislation for certain types of employers in the public sector, such as hospitals. Labor relations legislation applies only to unionized employees and to employers with unionized employees. Currently, approximately 4.8 million employees belong to a union, primarily in the public sector. Unionization continues to decline in Canada, with the lowest rate being among young workers. Labor relations legislation is usually administered through an agency called the Labor Relations Board. They are responsible for administering and enforcing this legislation. This board makes decisions on a variety of complaints from either a union or an employer. An employer might complain about the location of a trade union's picket, or union members might complain that the union has not fairly represented them. The board hires people to make these decisions, who are usually lawyers or who have some type of legal training. This will be discussed further in Chapter 10. As you will read about in Chapter 3, the work environment and well-being of employees are the responsibility of the employers. This responsibility is partially governed by legislation that describes the expected standards for health and safety in the workplace. The federal, provincial, and territorial governments regulate occupational health and safety. All managers and HR professionals need to become familiar with the occupational health and safety legislation that governs the jurisdiction under which their organization operates. The fundamental duty of every employer is to take every reasonable precaution to make sure an employee is safe. In addition to providing a hazard-free workplace and complying with the statutes and regulations, employers must inform their employees about health and safety requirements. Employers are also required to keep records and compile annual summary of work-related injuries and illnesses to make sure that managers are familiar with work and its associated hazards. Violations of health and safety statutes are administered through a government agency, frequently called the Workers' Compensation Board. As a part of the legislation, workers can receive a monetary payment if they are injured or get a disease that is attributed to their work. Thus, the employer is responsible not only for the health and safety of the workplace, but also for financial compensation if a worker is injured or gets a disease on a job. For example, if you are working as a nurse in a hospital and you injure your back caring for a patient, this would be reportable. Once you sought medical attention, if your back injury was deemed to be work-related and you lost wages related to this back injury, WSIB and the hospital, or your employer in general, would be responsible for your wages while you were injured and unable to work. Central to Canada's economic growth and prosperity in a highly competitive global marketplace will be a barrier-free environment in which all Canadians can fully explore and develop their career potential. Labor force stats described in Chapter 1 of your textbook indicated changing patterns of immigration, the rising labor force participation rights of women, and an aging population. Women, members of visible minorities, Aboriginal peoples, and people with disabilities are the designated groups under the federal employment equity legislation. These designated group members are entering Canada's labor pool, and they are a vital resource. Equity, by definition, means fairness or impartiality. In a legal sense, it means justice based on the concepts of ethics and fairness, and a system of jurisprudence administered by courts and designed primarily to decrease the rigidity of common law. The implementation of employment equity has involved the establishment of policies and practices designed to ensure equitable representation in the workforce and to redress past discriminations as they relate to employment and employment practices. Pay equity. As a result of a 1978 amendment to the Canadian Human Rights Act, pay equity is equal pay for work of equal value, and this became law. Federal pay equity law makes it illegal for federally regulated employers to discriminate against people on the basis of job content. The focus of pay equity legislation is to narrow the wage gap between men and women on the basis that women's work historically has been undervalued and therefore underpaid relative to the work primarily done by men. For example, the average hourly wage of men who worked full-time in 2017 was $28.69, but it was only $24.65 for women. One of the principles behind pay equity is gender neutrality, designed to reduce systemic discrimination pay practices. Iceland was the first country to enact a law to force employers to pay men and women equally. Pay equity is based on two principles. The first is equal pay for equal work. Equal pay for equal work means that if a woman and man are doing substantially the same work for the same organization or company, they must obtain the same wage. The second principle of pay equity is equal pay for work that may be comparable in value to the organization. Pay equity compares the value and pay of different jobs. This means that male and female workers must be paid the same wage for jobs that are of comparable value, such as a nurse, historically a female-dominated work environment, or an electrician, historically a male-dominated work environment. Implementation of pay equity is based on comparing jobs performed mostly by women with jobs performed mostly by men. Managing diversity goes beyond any legislation in addressing the need to create a fair work environment. The term diversity and employment equity is often used interchangeably, but there are differences. Diversity is about voluntarily having a more representative workforce. Employment equity is not. Managing diversity is a broader concept encompassing factors like religion, personality, lifestyle, and education. Frequently, you will hear organizations talk about inclusion as a part of diversity. Whereas diversity refers to our differences, inclusion is putting into action all those differences to create a very successful organization. An inclusive environment leads to better organizational performance. According to Statistics Canada, much of the increase in our total population over the next 25 years will be due to immigration. In this context, utilizing all of the individuals with the necessary skills and abilities is not about doing something because the law requires it, but rather doing something because the company will succeed. It's not just about racial and cultural background, but about accepting and understanding differences. Many different types of organizations in Canada recognize the importance of diversity and inclusion in their overall business strategy. It is important to remember that in Canada, diversity also includes Aboriginal peoples. In 2007, the federal government created a training program in skilled trades that will support apprenticeships with a focus on Aboriginal peoples. Transforming an organizational culture into one that embraces diversity and inclusion can be complex and lengthy. Diversity and inclusion initiatives should be taken slowly so that everyone can understand that this change is evolutionary. Leadership is one of the most important variables in an organization's ability to successfully incorporate the value of diversity into its business strategy. For any organization to become more diverse and inclusive, the process is one of changing its culture. This is not done overnight and needs considerable and consistent attention and support from all leaders. Given that becoming more diverse and inclusive is a cultural shift, all efforts need to be integrated, everything from recruitment to training to performance management. Training is essential to the success of diversity implementation. One area of training that we sometimes don't think about is the training and experiences that military veterans can bring to an organization. Breaking down barriers is also an important part of the diversity initiatives. As noted earlier in this chapter, diversity and inclusion are now a business imperative in our global environment. Canada, as described in the Deloitte report, has a unique opportunity to leverage its multicultural society to become more prosperous and stronger. Another element of successful diversity and inclusion approaches is evaluating the performance of behaviors on an ongoing basis. Measuring everyone's performance in regards to diversity and inclusion will instill the values in the minds of all employees and demonstrate that valuing diversity is a part of everyday success in regards to business. Throughout Chapter 2, the legal requirements of HRM are emphasized. Laws and court decisions affect all aspects of the employment process, recruitment, selection, performance appraisal, safety, health, labor relations, and testing. Managers must comply with government regulations to promote an environment free of litigation. However, beyond what is required by the law is the question of organizational ethics and the ethical or unethical behavior engaged in by all employees. Ethics are usually defined as a system of moral values, the things that matter to us that motivate our behavior. Therefore, ethics, like the legal aspects of human resources, permeate all aspects of the employment relationship. Although ethical dilemmas will always occur in the supervision of employees, how employees are treated is what largely distinguishes the ethical organization from the unethical one. An ethical organization recognizes and values the contributions of employees and respects their personal rights. Many organizations have their own code of ethics that governs relations with employees and the public at large. In addition, the Government of Canada has Ethics Commissioner reporting directly to the Prime Minister. The ultimate goal of ethics training and ethics commissioners is to avoid unethical behavior and adverse publicity, to gain a strategic advantage, and most of all, to treat employees in a fair and equitable manner, recognizing that they are a productive member of the organization. Even with the code of ethics and ethics committees, people do not always behave ethically. When something unethical happens, employees will sometimes report an organization's unethical practices outside the organization. This is referred to as whistleblowing. People will sometimes not report unethical actions or behaviors as they are concerned about revenge from those involved. But sometimes the unethical behaviors are so high profile that they cannot be ignored. Although some organizations install special hotlines or create other confidential ways that employees can whistleblow, this may not be enough. If employees can't trust that their story will truly be heard and acted upon, they may never come forward. Also, if they don't know who is answering the hotline or looking at these complaints, they also may refrain from complaining. If the organization does have a hotline, it's important that it is open to anyone, customers, public, suppliers, anyone that is there to serve them. Even though there has been recent changes to the employment legislation described at these sites, changes will continue as Canadian social values change. In summary, to ensure that employees understand the importance of dealing with unethical behavior, leaders play a crucial role in reinforcing ethical behavior by their own actions, as well as playing a role in encouraging and supporting whistleblowing. Whether an organization is small or large, there are basic guidelines to follow. Organizations need to be trustworthy. They need to maintain the confidence of their employees. They need to be impartial and objective. They need to be fair, and they need to try to avoid any real or potential conflicts of interest. Please take some time to review the learning outcomes and the learning outcomes summary in your textbook. There are also some close-up application activities in your textbook and some critical thinking questions that will assist you when studying for your exam. Please take a look at these in order to build your skills. Thank you.